Okay, our next panel is our whistleblower update, the impact on corporations and SEC enforcement. We have a great panel. Let me start by introducing John Carney. John's a partner at BakerHostetler in New York, former AUSA in New Jersey, and a former senior counsel at the SEC. Welcome, John. Next to him, we have Richard Grime, a partner of Gibson, Dunn, and Crutcher in Washington, D.C., also former assistant director in the SEC's enforcement division. Further down, we have Cree Kelly, who is the current chief of the SEC's Office of the Whistleblower. At the SEC, she's also served as counsel to former SEC Chair Mary Jo White and counsel to former SEC Commissioner Kara Stein. Welcome, Cree. In the middle, David Peavler, partner at Jones Day in Dallas. David, of course, previously served as regional director of the SEC's Fort Worth office. And our moderator, Nader Salehi, a partner at Kirkland and Ellis' Washington, D.C. office. He also previously served as counsel in the SEC's Division of Enforcement. Let me turn it over to you, Nader.
Thank you. Good morning, everyone. So I thought we'd just jump right in and begin with a conversation with Cree, who's probably the person whose views are most interesting on this panel. And maybe, Cree, we could talk a little bit about the recent spate of actions that we've seen the Commission bring involving 21F17 and agreements that the Commission has viewed as potentially violative. There have also been a number of recent statements by the senior staff highlighting the importance of this topic. What's behind this renewed focus on 21F17?
So, thank you, Nader. And before we get started, I just want to do the disclaimer that the views I express today are my own and do not necessarily reflect the views of the Commission, the individual commissioners, or the Commission staff. So, thanks for that. So, yeah, this was a really great year, I think, for the program and for the Commission. The spate of cases that you are referring to really highlight the Commission's commitment to enforcing Section 21F17 and our concern about any measures that are in place to prevent or impede whistleblowers from coming forward to the Commission. And so we've brought about 20 of these cases since 2015. We've been out there bringing these cases, and so it just sort of, we have a spate of them this year, but we've been unwavering in our commitment to enforce 21F17. We value the importance of whistleblowers feeling that they can freely come to the Commission directly, and this has been borne out in the enforcement actions this year.
So looking at the cases, you're absolutely right. There have been cases that have been brought since 2015, but from the outside, it looks like there was a sort of a spate of cases that were brought 2015 to 2020. The rule obviously came out in 2011. Then there was sort of a period of relative silence with sort of a trickle of cases, and then we seem to be seeing another slew of cases this year. And I guess the question that I would ask of you is there something that people missed in the cases that were brought in 2015 to 2020 that the Commission is now feeling the need to revisit?
I think that maybe the message wasn't getting out. I mean, these are not new issues, right? When we see agreements where there, language about, a whistleblower not being able to receive any, monetary compensation, notice requirements, these are things that we've seen before, and so it's really not new, and I don't know, I think maybe we've seen a period where this was getting out and it was sort of trickling out and people were making the changes, the companies were, but, it's just surprising to me that we're still seeing such the same conduct. And there's sort of different pattern. We've seen with language where, there's maybe some more permissive language in an agreement that says, yes, nothing in this agreement, prevents you from coming forward to a government agency, but also having a more restrictive. I've
been calling that the non-saving savings clause.
Well, I think that the Commission has spoken on this, and I think that that's something that's maybe something we're seeing that's newer, is having these conflicting provisions within the same document and across company documents. But when you look at the very type of conduct that's problematic, the language that we're seeing, it hasn't really changed from those early cases that the Commission brought in 2015 and 2016.
So one other thing that jumps out to outside observers when you look at these recent cases is, first, there aren't many that are just standalone 21F17, but when you look at the ones that are just standalone 21F17, there's a wide range in the penalties. And there's one that was recently brought against E. Shaw that had a $10 million penalty. And I think that struck a lot of observers as fairly significant and perhaps disproportionately large relative to the other cases that we'd seen recently. What drove that? How should we be thinking about that penalty size relative to the others?
Well, look, I mean, the penalty is always going to be facts and circumstances based, right? And so, I mean, in the early days, this was something new. 2015, 2016, that we're sort of, this is out there. Maybe we haven't brought a case in this space. At this point, several years down the line, with the many cases, almost 20 or so 21F17 cases that have been brought, it's sort of like, okay, you can't really say that you're ignorant. You don't have credibility.
It's never a good defense anyway.
Yeah, exactly. At this point, this isn't a gotcha. This isn't like we came out of nowhere. This has been out there for several years. And I think specifically with D. Shaw, we had a fact pattern where there was an understanding of, the sensitivity of not, impeding whistleblowers from coming forward. There was a company-wide email sent out in 2017 advising folks that they could come to report to an agency. But then there was a lag in actually including that type of language in, very important agreements. And so I think, that, probably contributed to that, to that higher penalty. But again, this is, as we go on and we bring enforcement cases with this provision, there's going to be less of a sort of a, where did this come from? Folks should know about this.
So I'm going to ask one more question of you, Cree, and then perhaps we'll open it up to the full panel.
I want to know how I got to be the only one on this panel. The prep session was really fun. I was like sharpening the elbows, anyway, go ahead.
No, thank you for, in all seriousness, because your views obviously are of greatest interest to people here, but just one more question for you, which is from the staff's perspective, what does remediation look like? Because we talked a little bit about penalty and sort of the range of the penalties. It looks to be the case that at least in some of the lower level penalties, the staff greatly credited remediation. So from your perspective, if not the full staff's, what does remediation look like?
Look, I think remediation involves identifying the problematic language or conduct, here language in these spate of cases this year, and quickly identifying it and making changes to your agreements and your training materials and your code of conduct and your manuals across, company-wide, so there's not these sort of inconsistencies. And sometimes, and this is going to be, facts and circumstances specific, sometimes there's actually going back to former employees and sort of saying, hey, FYI, there's nothing in your separation agreement or severance agreement that prevents you from coming forward to the commission. And so, those are just essentially a tone at the top and really valuing whistleblowers because they make your company better if they're boots on the ground identifying conduct that you may not know about. And I think to the extent that you can establish that tone at the top, that's going to be beneficial for everyone.
Terrific. Thank you. So let's turn to the rest of the panel. John, David, Richard. So Cree's, I think, articulated the view that I've seen in some quarters that these cases aren't really new. I'd love to get your perspective on it. Do you guys think that's the case, or do you think these new cases are new?
It feels new. Or maybe it's just the increased enforcement, and it feels new, and we've known it's been there, and it's been there, over a decade. And if I can ask a question though, just before we move into that, is so I could totally see situations where a whistleblower comes forward, and the whistleblower says, I was aggrieved somehow. You look at this, what was the company's provisions, and what were they doing, and that makes complete sense. But and just for the folks out there, if a case comes in, an accounting case just comes in, and there's no whistleblower whatsoever, are folks inside the division actually going to take a look to see if they had a policy on that anyway? So is that almost my question is it an every case type of inquiry now, where somebody who is there wasn't necessarily a whistleblower, but there was a case, and as part of that whole process, they'd want to look at the program, or that's not happening?
Do you mean in terms of how we identify which 21F17 and looking at agreements? Like
Yeah,
how we do that?
for example, if you get up a company that didn't have a whistleblower, where it comes in from an auditor, it comes in from whatever way it comes in, the company sells, but the company has a bad policy anyway. Is that something, is the staff looking at this in every case, or is it only looking at whistleblower cases?
Look, obviously, we learn of cases where there are whistleblowers that are concerned about particular provisions they've been asked to sign. There's cases in the course of doing an investigation, you come across, problematic agreements. So I wouldn't, necessarily say there has to be a whistleblower. I mean, I think in the recent orders, we've seen that there's language in there that says, there's no, indication that this particular agreement may have killed anyone, but on its face, it's problematic.
I think what John's getting at is, let's assume there's no whistleblower issue in the case at the get-go, but as the case progresses, as one of the check-the-boxes things the staff does, it's like, hey, company, send us your whistleblower policies, send us what training you've done on it, we're going to take a look at it.
Well, isn't the answer the facts in this case may be developed, lead to violations, other violations of the federal securities laws?
Yeah.
Yeah, I mean, look, I think that because this is out there, this is something that you should be looking at. We don't always know, you may not know that there's a whistleblower. So sort of generally you should be, you advising your clients, looking across their agreements and seeing if there is proactively, if there is any issue with the agreements. But, in terms of, you're not going to necessarily know if there's a whistleblower. We may, they're coming to us, obviously we conduct our investigation, accordingly. But,
yeah, I don't think it's necessarily just looking for a whistleblower. I think it's looking at the policies, because at the end of the day, this is a strict liability. There's no intent required. There's no harm required. It's essentially a paper policy. If you've got one, is it right or is it wrong? And it's right or wrong in the commission's eyes, not in your eyes. I mean, the interesting thing I thought about D.E. Shaw was, this is not a company that is trying to purposefully stop people coming in. It was a company that made an effort, clearly wasn't adequate, but it made an effort. But apparently the fact that they were making an effort and therefore apparently had knowledge of what the law was, which apparently is imputed to anyone anyway, is then seemingly an aggravating factor because they didn't do their remediation quick enough. So what I take from that is, be careful. The staff is watching it, and the commission and the director of enforcement was speaking yesterday about this topic, and this is obviously something that is an easy violation for the staff to find, because it's really up to them. If you happen to have a policy that says go and talk to the SEC, we won't restrict it, but you happen to have a separation agreement that says something slightly different, you may not be able to rely on the first policy. So you have to look at the whole ball of wax, which is challenging for companies that may have agreements across the world, saying lots of different things in lots of different languages, interpreted in lots of different ways, but ultimately the only interpretation that matters is Cree and her office and others. So it's a very interesting area to look at, because at the end of the day, the staff has a lot of power in this place.
Hey, if I could, what I would say is, I was still on staff less than a year ago, and it was not like okay, we've got this investigation into insider trading, or we've got this investigation into accounting, and let's ask about their severance agreements. That wasn't the way, at least in my office, in my experience, how we thought about it. That doesn't mean there weren't sweeps targeted at. It doesn't mean that maybe we were getting information from other sources that were saying this company uses these, and then it would be added. But it wasn't a default, well, we can't prove anything here, so let's go find this 21F17 charge. At least that's how we approach it. I know, there are obviously lots of other parts of the commission.
I think that the bottom line is that the commission values enforcing this provision and values it enough that to have standalone actions based on that, right? And so we have had standalone actions that we've had the provision charged in connection with other violative conduct. So, but we can learn. This is how we learn about all of our investigations. I mean, it's something that we might want to probe if we have something, if in the in unique facts and circumstances we see something that the whistleblower says. and we go down that route. I mean, the bottom line is really, it seems sort of like a little bit of a red herring. I mean, the bottom line is like, I think, less worried about whether the commission is going to be sort of looking at this in addition to other, other securities law violations. The bottom line is to sort of advise your client to get the house in order in terms of these agreements, because we have 10 years of cases, enforcing this particular provision.
If I could just answer the question that I asked a few minutes ago, are the new cases really new? I just want to share my perspective on it. Is what strikes me as new is I think the new cases show that savings clauses, when they're generalized, are not enough. And you really need to, as I think Richard was saying, take your agreements, look at them in whole, look at all your agreements covering a whole bunch of areas, and really look at all the provisions, because to the extent that, in 2015 to 2020, people took their agreements and just added a sentence or a paragraph that said, nothing here is designed to preclude you from being a whistleblower, the message I took away is that's not enough. And the new cases say that if that conflicts on its face with a confidentiality provision, you may have to add a caveat to your confidentiality provision. And so, I do think you're absolutely right. People need to be revisiting their agreements. Let me ask a quick question. I welcome the group's view on this scope. There was a case, Collector's Coffee, a couple years ago, made the point that 21F17 doesn't just apply to employees, it can apply to investors in that context. Does 21F17 really apply to everyone? What do you guys think?
I think the way the rule is written, it does. It says anyone, who could be impeded, and I think that's played through in the cases that the SEC has brought. So yeah, I think it is as broad as you could possibly imagine in terms of impeding.
Does it apply to an agreement that I sign with a company that's a service provider that provides paper and coffee to my office? Could it theoretically apply to them if I have an overly onerous confidentiality provision? I don't see any reason it couldn't.
In theory, it doesn't, but I mean, the scope is it's a reporting of a securities law violation. So if you're supplying coffee, maybe, probably not, but you never know what else that company's doing as well. And it does talk about, as David said, any person. So that, and it applies obviously to private companies, which I think was not a surprise if you really were reading the tea leaves or the coffee and collector's coffee, whatever the pun is. But at the end of the day, Monolith comes along and then there it is. Again, a private company. Think about the thousands, the hundreds of thousands of, companies out there that now seemingly private companies didn't think the SEC was really a regulator except in very limited circumstances, are now a real regulator of this space. And people, it's individual actions they brought, individual actions. Hansen is another one. So this area, as much as you say, is it more of the same? Everything's sort of more of the same, and then there's a but. It's being emphasized, but the penalties are getting higher, but the remediation is getting more, detailed, and the less the excuses, as Cree is pointing out, come from, it's been not only been around for a couple of years, now it's been around for 10 years. Look, the securities laws have been around for close to 90 years. That still doesn't mean that everybody knows what the hell they mean. The Supreme Court doesn't seem to know what it means. So it's all very well saying, this has been around for 10 years, but with the greatest respect, rules are interpreted in different ways by different people at different times. I'll take that with a pinch of salt. We're now onto salt now.
Okay, so let's do this. Let's turn to some hypotheticals that I think we sometimes deal with on the private side that are thorny and challenging. We've been talking about agreements, and I want to turn a little bit to actual real world whistleblower issues. So here's a hypothetical that I think we've all dealt with. Company has received an anonymous whistleblower report through its internal hotline, but the report is vague, it's generalized, and you need more information to really understand what exactly is this person saying. And so the company's taking it seriously, the hire outside counsel, here's this generalized whistleblower hotline report that I received, and I want you to look at it. So you come in as the outside counsel and you start to investigate. What can you do and what can't you do in that sort of a situation? Obviously with an eye towards 21F17. You need to investigate so you can address the issue, but what should you be mindful of? You want to start us?
Yeah, I think the first thing, and this does come through the enforcement actions, is what is it you want to find out more. You're taking this seriously, which is very important to the staff, clearly, but you need to find the person, or you feel like you need to find the person. And I think this is where your intent can matter. If you're looking for the person so that you can do something to limit them or to retaliate or to cut off their access or anything of that nature, I think that becomes problematic. But if your intent is, we want to know more, we want to understand more, and you're trying, I think, in good faith to find that information, I think that's the line that it can be hard to straddle, but I think that is a line that, because otherwise, if you just ignore it, if you just, I see Cree kind of expressing anxiety here, but if you just ignore it, then you can be, the SEC could look at you and say, well, you got this complaint, you didn't do anything.
Well, let me just jump in here. I think it's if you don't take away anything from this, please do not try to find the whistleblower. As tempting as that might be, please don't. I think that you conduct the best investigation that you can with the facts that you have. You're in the best position to know who in the company is involved in this particular area, and do a thorough, investigation. And, obviously, if someone reports anonymously, they don't want to be identified. So I would just caution you to be very careful about that. Obviously, if you're conducting an investigation and you talk to the whistleblower in the course of that, okay, that's one thing. But I would just be very careful about doing that. You conduct the investigation in the best way that you can, and you'll see where it goes.
I mean, you alluded to sort of looking at network results. I mean, I look back at the Hansen case, and I think that left a lot of us sort of a little concerned and a little confused. In your experience, I mean, Richard, you're nodding. Do you tell clients they're allowed to look at their networks and try to figure out who's been where, so you can? I mean, let's assume good faith. Let's assume with the best of intentions, you're trying to figure out what's this allegation based on. Can you at least go into your network and try to figure out who's been downloading what documents and what concerns may be at issue?
I think you do it with great trepidation. I mean, it's eyes wide open, knowing that there's a real risk here. Most people don't start, at least clients I tell, don't go and, at least if the instinct is to go find the person. That I totally, and I tell them, no, just don't. Just don't. It's not, you're not going to get anything out of it. And anonymous whistleblowers, you can send, if you can contact them, sometimes they leave no contact address, but sometimes they do leave a contact address. Just periodically reach out. Is there anything else you want to send to us? So there's at least a record that you've got an open channel with them. And then, like Chris said, just try it and look at if you've got whistleblower logs in this area. Have you got complaint area in this particular? Is there anything you can decipher? Is this how much resources you're going to spend? Because these things are not cheap to enforce, to investigate. So it's all very well for us saying, do a full-blown investigation, but that's tens, hundreds of thousands of dollars. You want to be judicious, but you also want to be recognizing that, the SEC is going to think you need to have, done it very thoroughly. But I think at the end of the day, it's the integrity of the investigation that's really going to be important here, as opposed to you happen to come across who you think might be the whistleblower. And the other thing I've seen is, I took over a couple of different investigations where somebody had been showing the whistleblower complaint to witnesses during interviews. That doesn't seem to be a great idea either, because for all of it, I can hear the room. It's not, but I've seen that happen. So you have to be, I don't see that as a meaningful exercise. What you're trying to do is find out, is there a violation here? What do you need to do? Do you need to remediate something? Is there something that needs to be addressed or not?
Yeah. Well, go ahead.
Yeah, I think I agree with everything that's been said. And if you go into it almost, like a blind taste test and just say, okay, we're looking at this thing and we're not even thinking that there was a whistleblower, let's do it. Because equally bad would be not to do anything and then 2 years later, wind up in a different part of the Division of Enforcement saying, why didn't you go look at this? And if it wasn't a whistleblower. And our clients are not securities lawyers by the most part. General counsel's out in the middle of Oklahoma or someplace, and they're going to be like, well, let's find that person. And I'm like, so the first thing is to get them convinced that that's not the goal. We're not trying to find this person. We're just trying to do a good job. I think this gets complicated in situations where you've started an investigation and you're 9/10 of the way through, and somebody decides, I'm going to pull the ripcord to try to save myself. That's different, and that happens.
So that's actually a great segue to the next hypothetical that I think we were going to put in front of the group. We've called this the conveniently timed whistleblower. So here's the hypothetical. You have an executive with whom you've had long-standing performance issues. You put that executive on a performance plan. The executive, by all accounts, is on their way to being terminated. And then shortly after being put on the performance plan, he comes forward and says that he has these concerns about reimbursement policies that may have been abused by other high-level executives. And so the question I have is, you've been brought in as outside counsel to start to investigate this. How does the investigation change or not, given that this person is on a performance plan and may have independent and real performance issues? How do you juggle those two things?
I guess you still stay with the program. You start with the program, narrow, keep the blinders on, just looking at the actual facts and things, and not trying to get too focused. An interesting thing in situations like this is that person, likely going to be a target of the SEC's investigation because they were a bad actor, and in which case it's much harder, because then you're thinking, well, I do have to get this person out of that position, or I do have to expose what it is. I do have to understand better. And I'm assuming these are situations where there's been no report to the SEC. And so in situations like that, you have to raise the question, does it make sense to talk to the SEC, at least preliminarily, saying, hey, we're doing this, and we want to have our cards on the table. And frankly, in a situation like that, I would often ask the staff, what do you want us to do? And because, I know, that'd be a hard question to ask you or something like that. So we think this person's like this, but the company wants to be so upfront with the staff that we're just trying to be completely open with this, including what to happen with this person. I think we'd get points for that.
So, but do you actually have to not fire the person because they're now raising?
No, look, they don't get they don't get immunity, okay? So, but they do get, basically, in reality, some protection. Because you're tentative and careful about what you do for the very reason that you don't want them or the SEC believing that you're retaliating against them. So it's a balance. They're in a different bucket than they otherwise would be. But you can essentially run these two investigations, the performance one and the underlying one, somewhat in parallel. And it may be that during the course of the performance one, you feel that person's performance is just not adequate for the job they're doing and the pay they're receiving. And you can fire them, but you know that if you fire them, you know where they're going, or they've already gone. They're going to go to Crete. Hey, I got fired because I reported something. You know that. So it's full disclosure to the client, that's what's going to happen. What do you want to do? But they don't get immunity just because they say, hey, I'm a whistleblower. But you have to be very careful, because they are going to allege retaliation for doing what you believe is an appropriate remedial act, which is getting rid of somebody who isn't doing their job.
So, and the only thing I would add there is, look at I'm not a labor and employment lawyer, but is the performance issue well documented? Mm-hmm. If there is a separate standalone record that this person has these issues, it's been well documented, you would be able to defend a private right of action, which the person could bring for retaliation. Then I think you're justified to move forward as you would even without the whistleblower complaint. But it does add that level of, or layer of complexity that you have to advise your client to be aware of.
Mm-hmm. So Richard, David, what do you guys think of John's suggestion that maybe you pick up the phone, you call the staff, and you say, you know what, we're going to be taking this employment action. We just want you to understand this is what it's about, this is what it's not about. What do you think of that as a proactive step?
It's not my first step. I don't, once you've opened that door, you can't close it. But you also have to recognize that, they may have already gone into the SEC already. So a question is, you're balancing that if you think they've gone in, then clearly there's no downside in picking up the phone and saying, here's the deal, this is what we're doing. I don't know, if you ask them, what should I do? I rarely get a constructive answer. But maybe it's just the staff, and maybe it's just my antagonistic old brain.
It's that.
I get answers. I don't know what you're talking about.
So, but I think you do. Look, I think you have to be careful about picking up the phone all the time. But in whistleblower cases, people go there to the commission relatively frequently. There were 12,000 complaints last year. So I think you have to be assuming that your person is likely to have gone there, in which case if you know that, then you would be picking up the phone.
And just to sort of address, I don't know if you can hear me. Can you hear me? Okay, if you can, this specific fact pattern. You've had time, this client or this entity here has the timing, it's on their side. They've sort of already established that this is a problematic employee, it's been documented. That, I think, is a very helpful point for the company in this case, because it doesn't seem like it's in reaction to a known whistleblower. And so sort of following up with Dave's point, it is sort of good sort of practices of documenting, complaints, investigating them, and just having, just good, culture of doing that, so that when this does come, it doesn't look like it's a reaction to a whistleblower, raising an issue.
I also think there's a huge difference on, whether it's a really technical issue or it's something really bad, or if you can look at whether it's good or bad faith from the whistleblower. I think I told some of you a number of years ago, I had somebody come forward to a client and said X, Y, and Z was wrong with the company's operations in South America. And we looked, and actually it wasn't, the person just totally misunderstood it, but they wanted to come down and meet with the staff, and for whatever reason left me a voicemail 2 hours before the meeting with the staff saying, hey, I'm going to go to the SEC. If you want to increase my severance by $100,000, I'll cancel the meeting. And it was recorded. That's one we went to the staff with.
Mm-hmm. That sounds like a good call. So one more question on this fact pattern. You have this employee on a performance plan. They've now alleged that they have these concerns. Can you limit this person's network access? Can you take steps to make sure that this person isn't going to parts of the company that he or she doesn't need to for their day job? Okay? So this person works in Division A. Can you take steps to make sure they don't go to Division B? Assume, for purposes of the question, there's no work-related reason they need to go to Division B.
Go ahead. I think the answer is yes, you can do it. But you recognize that the provision is you're not supposed to harass somebody. Where that person will say they're being harassed by not allowed to go and open doors that they're not supposed to be doing, who knows? So yes, you can do that, but recognize that every step you take and the other part is, what do you typically do in this circumstance? What's your consistent policy in this? Is this because this person has now made a complaint that you're now doing this? Well, that's not so great. If this is what you do to routinely people who you're looking at performance issues on, you are careful and just take a look at, maybe there's a benefit. But it's a facts and circumstances determination.
Yeah, if someone had access to another area, even if it wasn't a part of their day-to-day, but they generally had access to it, and you limit that could, I would raise the concern, because you're changing a condition of their employment, something that they did have access to before. But, we're not trying to, and, I just want to say this, we advise our enforcement staff, as Dave knows, they're the ones bringing the cases. We advise them, work closely with them on these 21F17 cases. So anyway, I just wanted to
But I think you raise a really interesting question, which is, this is where the SEC is getting into the employment space, right? They're essentially looking at, what does harass mean? That's not typically what the SEC, in the 34 Act was doing, but they are now looking at whether somebody has been harassed. And what does that mean? That's typically employment law venue, but this is what's happening.
This is a very real world issue. I mean, this hypothetical is one that has come up several times for me, and you talked about limiting their employment, but for purposes of the hypothetical, sometimes a company will say, hey, I haven't been really careful about who has access to what. Now that I have this potential whistleblower issue, we need to be more careful. We need to make sure people are locked down. If this person is really alleging issues, fine, but they shouldn't be allowed to roam around the company. Is it really impeding them if you say to them that they can't go to other areas of the company that they don't have a reason to go to? I mean, my personal view is it's not, but I tell people you need to be careful, because somebody else might say it is impeding.
Well, and it goes to the idea of whether the actions you're taking are a pretext. Somebody who has been had positive performance evaluations or considered for a promotion, and then all of a sudden they raise a point, concern with the company, and then they're put on a list to be terminated, or their access is limited, or they're not allowed to go to the conferences that they've traditionally gone to, then it looks like you're taking steps out of the ordinary course. And I think that has to be looked at. You look at the big picture, and if you took the whistleblower complaint component out of it, would you treat that same person the same way, or are you now treating them differently than you would have because of that?
That's what the SEC was getting annoyed about in Paradigm. Essentially, there's a litany of issues and the way in which this person was treated as head trader that the staff felt, you're doing this because he complained. And if it's that message that is in any way going to be interpreted by the staff in that way, you have to be careful.
Well, is that true even if what it is that you're doing is something that you're entitled to do? So for example, somebody has taken company records home and you ask them to return it. Okay, let's assume for purposes of the question that you're entitled to demand return of those documents, and the person is now a whistleblower. Are you no longer able to demand return of the documents because the person's a whistleblower?
I think you can, well, it's interesting, right? Does that hinder their communication?
Real world example, right?
Does that,
it happens all the time.
I think, they will say, well, that hinders my ability to communicate with the commission, right?
Correct.
Because, hey, I don't have the documents to refresh my memory or show to the staff.
Right.
My view would be that is something that you can request, but they're going to make that argument. So the question is, are you going to prevail in front of the staff in that circumstance? But it's a real world. I agree with you, and I think it's something that you can do, but
I know John would say you can demand the documents.
The staff may say that's hindering that person's ability to communicate with us. I would say that's not hindering their ability. They're able to tell you what's in those documents.
And again, is it a known whistleblower at that point, or you're just generally going through and asking people to return things? And you're generally doing it. I think that's fine. And we kind of touched upon it a little bit, but I mean, we have a fairly large employment practice at the firm, and so that first call I make is to the head of employment when there's one of these issues, because I don't know what the law is in Texas or in Ohio and what all the other possible things to go on, and their own state whistleblowing and things wholly unrelated to the securities laws. And I think you'd be making a mistake just looking at this.
Mm-hmm. So, but maybe, Cree, I'd love your perspective on this. Let's assume for purposes of the discussion that you're entitled, the employee has taken documents he or she isn't entitled to take, and they're a whistleblower. Does whistleblower protection mean you can't demand documents back?
Look, it's going to be fact and circumstances based in this case. I would be very cautious about asking a whistleblower to return a document. The cat's out of the bag at that point, and in terms of them actually having possession of it, and realize I would consult your counsel, these folks, others, obviously, to advise you on this, because this is wrought. This is dangerous, in terms of a potential perception that you're impeding a whistleblower from coming forward. I mean, look, with Hansen, which came up earlier, I mean, that was if you look at that order, that is almost, in my view, pretty egregious conduct, and so I think that there are certain types of cases that we would not necessarily recommend. If it's someone stealing trade secrets or there's something like that. In this particular case, I thought that the conduct was very problematic.
But aren't we? I mean, this kind of taking the conversation we had before we came on stage. We've got a rule that's like one sentence long, and it doesn't tell you all of these. You can't do this, and you can't do that, and you can't do these other things. And I think it ultimately boils down to trying to interpret what does the SEC think, and advising your client that the risk is there. You might do anything because the SEC might think is problematic. I think you have to ultimately go back to, are you doing this in a consistent, good faith, for a good faith purpose? Is it documented? Is this how you would treat any employee? And I think if the SEC comes back and says, well, this person's a whistleblower, so you shouldn't have done that, I think you have to be willing to stand up and say, well, this is what we do for every employee. We can't change our entire process, our entire policy, because this person has happened to go on and made a report to the SEC. I think, look, I know it's risky, but like I said, there has to be some control that companies can have over their data, over their documents, over their secrets. And it can't be that the whistleblower program drives every other decision.
So maybe just in the 5 or so minutes we have left, we could turn to remediation. Because I think that the cases have made clear, especially the more recent cases, that companies need to go and review all their agreements and look at them in whole. Question for the group, do you guys think that remediation means, to the extent you leave here, you sort of say, I need to go back and look at my agreements, you look at your agreements, you identify several agreements that have been there for 20 plus years that have confidentiality provisions or claims, relinquishment of claims provisions that arguably are violative of 21F17. You remediate by improving the language going forward. What else do you need to do? Do you need to go back and reach out to people who signed those agreements? Do you need to tell them, hey, I know we spent 6 months negotiating your release from the company, but just so you know, you can now go to the SEC and tell them that you thought of 13 other violations? What does remediation look like?
I guess you'd start with a little bit of triage. I think the whole panel would agree you have to do something. So doing nothing is not a good idea. If the case is literally 20 years old and it's been a long time and it was before the statute was written and the rule was promulgated, of course not. You know what I mean? And if it was even beyond the regular statute of limitations, I would think probably less so. And if it had absolutely nothing to do with any suspicion of misconduct by the company or anything else, just a riff or something like this, I would put that in a different category versus ones where there were executives or people who were in the know that possibly were sensitive, and I would take them case by case.
I think that's right. I mean, there are enforcement orders that talk about companies who got the SEC's blessing to contact former employees who had separation agreements that otherwise the staff thought was improper. So I don't think that's a highly risky proposition to start reaching out to hundreds or maybe thousands of employees and saying, hey, just so you know, if you had any issues that you didn't tell us about, because there's this clause in this contract which you may or may not have read or even understood. By the way, why don't you go and tell the SEC about it? I would be surprised if many companies are in that, but that is in the remediation of one of the orders. Look, another one is obvious: training, right? Training, and to Cree's point about tone at the top. The staff says, well, do you train your employees? Do you train your legal department? Do you put out posters? Do you have a currency that this matters at the organization? Those things are useful optics as well as meaningful measures that can be taken. But you need to review both the policies and the contracts because, and it's a worldwide proposition, right? I mean, CBRE says that's what they did. It went to 60 different countries and looked at all of their, so this is not a done overnight process. But if you want to be able to be in a position that you can look at Cree in the eye and say, we've done everything we can possibly do, then these are some of the things you should at least consider doing, but it's a risk analysis. You start with the worst offending provisions and you move to change those. But you should assume that once you start this process, like any investigation that starts, people come out of the woodwork. So, don't be surprised if a few whistleblowers come out and say, hey, I was going to say this, but I somehow didn't know about it until now.
So maybe we'll just try to close it by going back to you, Cree, with one other question that I'd love your thoughts on, and obviously the groups. There's a little bit of tension sometimes between cooperation and the cooperation credit that companies want to and seek to receive, and this concept of whistleblowers. And I'd love to hear your thoughts on how does the existence of a whistleblower limit, if any way, the ability of a company to get cooperation credit?
Well, the short answer, it doesn't. I don't think that, folks should be, sort of concerned, oh my God, the whistleblower is going to report before we have a chance to kind of thoroughly investigate. I think you should just assume that a whistleblower has already reported, as Richard, I think, mentioned. And so I wouldn't get caught up in that. I think the most important thing is to do a very thorough, robust, comprehensive investigation if you learn of misconduct, and that's making witnesses available or whatever the things that you think that you can do to help the staff understand what went awry here. But don't sort of think that because you didn't report before the whistleblower learned of the conduct, that there's not an opportunity for credit.
So you can still play your cards the same way.
Just if you conduct a thorough investigation, we've seen it in a case this year, GTT, where we had no penalty in enforcement action, and so the whole point is just to identify if you see the conduct, timely initiated an investigation in a timely manner. Don't have the possibility of the whistleblower having reported it to the commission and it's just been sitting around for months, and you're focused on trying to find the whistleblower or who. You just sort of do a comprehensive investigation, and I think that let the chips fall where they may, and I think you will, get that will be perceived favorably. I can't speak to specifics about that, but whether you get specific credit, but it will be the staff will value that, and that will be communicated in the recommendation.
Thank you. Thanks, guys. I think we're out of time.